Yeah, right. Hi, everyone. Lyric Armstrong here, your real estate advocate. Okay. So, guess what? We need part two. We got to find out. Now, Old Squishy Garden's calling her a Karen tenant. And so, I don't know. Tell me, do you think she's a Karen? For me, Karen is a person that causes a problem and then cries about a problem and wants to see the manager. They've got to see, like, they can't resolve it with you because clearly you are incompetent. So that's the Karenist that I can relate to, I guess, that I know, that I've seen. And then, of course, all the racial Karens, I've kind of dealt with some of those. But I don't know if this tenant is a Karen. We saw the last video, so tell me what you think. Is she a Karen? Is this a Karen tenant? So we're in, Judge, where did you go? Judge Simpson. Yes, we love Judge Simpson. So Old Squishy Garden is the channel that has supplied this video for our enjoyment. Go ahead and like. Here's the thing. Oh, and he doesn't. Oh, yeah, he has 4,000 likes, but 125 views. Come now. We enjoy watching someone give us content and information. We can very much do the simplest thing and like their video. Otherwise, we wouldn't come back, right? So I'm back, and so is Karen. So let's find out what Karen's about, because this is part two. So if you haven't seen part one, go ahead and see part one. Very interesting lady, very interesting an ailment. Someone reported or communicated in the chat that is a mental illness. And I think kind of all illnesses have some basis in the mind, but nonetheless, I don't know if that means you can treat it with certain mental drugs, or if you have to live a life much as she has described, because she describes a very strict regimen. Anyway, go check part one out. And this now is part two. Part two is all about the money, honey. Tell us about the money.
Good morning. Camel Appeal.
All right. Ms. Miller, are you there?
Yes, I am, Your Honor. I am present. Thank you.
Okay.
Let me make sure I don't have them too fast, because I like to. Yeah, I'm on 2 points. I like to keep them fast so I can read it, so I can hear it all the way through. Here we go. I'm gonna turn it slow.
State your name for the record, please.
Nancy Rose Gertler.
Thank you. All right. Have you seen? All right. Have you two talked at all in terms of resolving this, or where are we on that?
No, we have not.
How much is your claim?
I'm requesting a money judgment of $12,406, which includes unpaid rent of $12,950.
$12,900.
Out-of-pocket court costs.
Hang on. Give me the rent again.
Yeah. $12,950.
Okay.
Which is on the balance statement that I gave Nancy Rose. Out-of-pocket court expenses, $215. Court serving fee, $68. And then after we inspected the house and stuff, I added cleaning fees of 5 hours at $20 an hour, 2 extra days rent at $34 a day, and two.
Question. So my landlords here, and me myself as well, would not charge a cleaning fee unless I've had to remove bulk items, because you're gonna clean it you're gonna have it clean anyway, like I would. But does everyone else charge a cleaning fee? Should we be charging cleaning fees over here in Cali?
The amount of that totals $13,401.
$13,401.
I then deducted the security deposit that she had.
Okay, which was how
for
much?
$995, and
how much?
Up to $12,000.
How much was the security?
$995.
All right, and then that's how you get to the 12,406.
Yeah.
Okay.
So this is why this part of the case is after moving out, because there has to be a determination if there's actual physical damages owed, that has to be reimbursed by the tenant. So when you don't have a court involved and you're a tenant and you're moving out, you make sure you do the final walkthrough so that you can have some statements done by the landlord that will say, oh, this is a pre-existing damage. This is how the tenant received it, or everything's in the clear, or these things the tenant has disturbed and we need to get quotes on what it will cost to fix. So you want to have a walkthrough done, and then consequently the landlord is going to give you a list of the things rightfully in alignment to whatever the walkthrough said. These are the things that need to be fixed. Here are the contractor invoices and quotes, and this is what's going to be owed by the tenant. So this is this element of time when you are, after you've moved out and the landlord's coming back to you and saying, okay, you've caused X amount of damage. Now you have to be completely moved out. If the landlord does a walkthrough and you're not completely moved out, that's a horrible process to be in, because maybe you hired movers. Hopefully you got insured movers, but maybe you hired movers that put a hole in the wall when they were moving out the bed or the headboard or whatever. So make sure that it's done once you've completely moved out and you have a copy of it. And then this is a part of that process in the legal sense of going to court and getting it done.
Okay, so out of the gate, you're going to have to add $2.55 because the service fee, as the court has it, is $70.55, not $68.
Oh, okay. Oh, I thought it was,
The
okay.
what's also going to come off of the total amount is going to be the 5 hours of cleaning.
Pardon?
The 5 hours of cleaning. So the $100 that you put on for cleaning also it needs to be deducted.
From the security deposit? Or I
Probably
put
don't
it
want
in
to do it that way, but it's going to have to be deducted off of your total.
Oh, okay, so I can't do that.
Can't do that.
Okay, all right.
Okay, so Michigan's not doing it either. I didn't think so, but you're learning. Every state has the ability to do as they see fit, but we are learning that when it comes down to it, when you're cleaning the property, unless it's bulk items and something that they've left behind that's egregious, you have to document what that is, and pictures, are 1,000 words. Atypically, cleaning is a part of the process, and it's not necessarily against the tenant.
That's
That way. And then the 2 days of rent, that was for what?
Nancy Rose was unable to move out on the 31st as the judgment requested, and she stayed till midnight, February 2nd.
And Ms. Gerler, do you agree with that or no?
No, Your Honor, I do have some comments regarding what.
Well, I understand you have comments. I'm dealing with just this issue. Were you there the 2 days beyond the 31st?
I was there the 2 days beyond the 31st. It was my understanding I had up to 10 days to vacate, and did not believe that there would be.
We know she had to be out. Wait, was that the other case? What? Hold on. I thought she had to be out on the 17th.
Beyond the 31st, it was my understanding I had up to 10 days to vacate, and did not believe that there would be an additional sum for those 2 days, which were spent cleaning, and professional cleaner did clean the house.
Okay, it's fine. I'm dealing with this one by one. And so I'm just telling you, you're saying you did occupy the unit those 2 days.
Yes,
for whatever the reason. Okay.
Yes, you're.
All right. Now I'm going to ask a general question, Ms. Gerler, and I need not a highly specific answer, but just this. Of the $12,406, is there any amount of that you believe you owe?
Your Honor, what was in contest at our last hearing was my stated concern that I had enlisted the help of Miss Biles at Faith in Action, and we could have been brought current at the first problem, and it was just shy of.
So here comes her math. So let's refresh ourselves. Her math is $3,000 was going to get paid at some point in time, which would have brought her current. Consequently, that should be shaved off. The other thing is this entity was going to give her $5,000 for which she didn't agree to. So consequently, that should be shaved off. And then we had something else that she had another entity who was going to give another $3,000. So that should be shaved off. So consequently, she doesn't owe anything. Her hands are clean. That was her math. That was her math last time.
Would have been brought current at the first problem, and it was just shy
Ms.
of
Gerler, Ms.
$300.
Gerler,
Sir, I just want to.
listen very closely to my question. Of the $12,406, which is primarily consisting of rent, is there any amount you believe that you owe or admit that you owe of that amount of rent?
Sir, if we were able to subtract the 3,000 she might have gotten, yes, then I would say that I am responsible for the balance.
Oh, okay, so she stopped there. She didn't go for the other. I think she had Hawk at 5,000, and there was another entity at another 3,000. She was doing some good math last video, so make sure to check that one out. Part 1. Interesting enough, so she's now only saying the original 3,000 that she might have gotten. Well, you know, if I buy a lottery ticket, I might win, but if I don't, I don't. So how are we calculating this funds?
So what your claim is that if the 3,000 had been paid by the outside agencies, what you would owe at this time would be the $9,406.
Are you worried that using your home
Your Honor, yes.
Okay.
When I talked to when Faith in Action approached me, they offered $800
How much?
1 month, and nothing was.
They offered what?
They offered $800 toward her rent.
Right. What?
That's all
I
knew about.
understand, but what I'm getting at is, and I think what Ms. Gerler's getting at is, had Faith in Action plus what would have been the other agencies of Hawk and the like, she would have gotten a maximum of 3,000. I think that's what she stated the last time. That's what she continues to state at this time.
Okay.
Okay, so the landlord is saying I was only offered $800 for the month. Judge Simpson obviously is well aware of the different agencies, so he's quoting Hawk, a different one, and saying if they all contributed, it would have equaled to 3,000. Math unknown to me, but okay.
All right. So
And
while she's pointing to one agency, I understand what Ms. Gerler is indicating, that there's this other agency.
May I respond to that?
To which?
To the $3,000.
I don't. Okay. First of all, here's the problem, ladies. You're fighting over stuff that doesn't make sense to me right now.
Good. I thought it was
okay.
Judge was acting like he understood. I was like, dang, he gets it. I don't.
And let me tell you why.
It's all right.
Ms. Gerler admits she would owe the 9,406 in essence, and I appreciate her candor on that. There's now going to be argument over this 3,000 that Ms. Gerler says, because you're saying that they're only going to pay 8. I get where Ms. Gerler's coming from because what I just said. Here's the problem with all of that. The problem with all of that is there would have been no payment with these programs if the tenancy wasn't going to be maintained.
Oh, okay. So I do know a thing or two. That's what I thought. So last video, I'm like, wait, but they're not going to pay unless you maintain possession, period. So the defendant's assertion that I would have had all of this assistance had she agreed doesn't really sniff water, because she is lost tenancy rights. So they would not come to her aid. I also feel like, I don't know how Michigan is, but like in California, you can't, or at least in LA County, you don't force a landlord to accept Section 8 or force a landlord to accept some outside funds. Now, granted, landlord wants their money, so why wouldn't they accept it? Sometimes it has to do with terms. This particular landlord is saying that the only thing they truly offered her was $800. So she didn't have knowledge of a full amount. But here's another thing. If the tenancy offered $800 for one of the landlord to attest and contend that that's all that was due and the balance was forgiven, even if she was trying to stack other agencies to help pay the full balance, there would be an issue there, because if she agreed to the balance being forgiven. So I don't know. But anyway, we're going to let the judge do his thing because he's the judge for a reason. So Judge Simpson, educate us.
The problem with all of that is there would have been no payment with these programs if the tenancy wasn't going to be maintained. So the 3,000 wouldn't have come in. But I understand Ms. Gerler's point that, okay, it may have come down to this point, but if you had taken that money at this point, then I'd be 3,000 to the good, basically, is what she's indicating. All right. So let me just.
I never got anything in writing to that effect. And they never
Okay,
said that
so-
to me over the phone. I didn't know about Hawk. I didn't know about any of them.
Okay, I get that.
Let the judge cook, as they say. Let him give you an understanding. He's working through the legalities and liabilities of the claim. Now comes down and is against you, then you can give your defenses. But right now, let him cook.
What are you guys really fighting over?
I just want to be paid the rent that I'm owed.
Okay.
And that she promised to pay
Okay.
each month.
And Ms. Gerler,
Yes, Your Honor.
are you working?
Not at present, Your Honor.
All right. And so
I only have Social Security income.
that's what I thought. You have Social Security,
Yes.
the SSD or SSI? Which one?
SSI.
I can sit here through a trial. You can put on your proofs. You can do whatever. She's admitting basically to almost
We're doing
3/4 of
another
what
trial?
you're saying anyway, right? Because she's admitting.
I think better call Saul. What does that mean? Oh, squishy guardian. What does that mean? Better call Saul. I think that the landlord should just let it go. I'd be like, look, just put the judgment in from a 9. Okay, let's agree that she owes the 9. I would just let that part go.
To the 9 for 9,400. The 3,000 may be a question, but I've said what I've said. But here's the bottom line, and why I'm trying to figure out entirely why we're here. And let me and I'm going to do this just in terms of the practicalities of it. All right. We can go through the trial, and I don't mind. You guys have my time. I can sit here through the trial. The cold-hearted reality of it is Miss Teal, you come down to the end, and let's say, just by hypothetically, and I'm not saying this is the way I'm finding, I find entirely in your favor, and I give you that judgment for the 12,000 plus. Let's just say I do that. How do you intend to get that money?
Here's what you're gonna do. Use this app.
Right.
Your Honor, it was a matter of principle.
Okay, I understand.
She's on principality. Listen, okay. We're gonna throw the baby out with the bathwater. Come on. I understand her issue to some extent. She wants all her money. She's owed it. So, we shouldn't have an argument. But you got to remember, sometimes dying on the hill means, you lose more than what you gain, because now you're going after principle. You win the case. You can't pay it anyway. But how much money, time, and effort are you out of trying to get that judgment?
Understand. There are principles all over the place, and people can fight on principle or whatever. My question is how would you intend on getting that paid? You told me you want the money. I get it. But how are you going to get that?
Well, I don't know, but I also make about the same amount of money in Social Security as Nancy Rose does, and that income was dependent on. And I worked hard, and
I appreciate all of that.
Just one.
I'm just getting. No, I know.
I'm not rich.
I'm not saying that you are. The reason I asked about her income.
I appreciate the landlord saying, I can't pay her bills and mine, Judge. She has to pay her own bills.
Is because that's where any judgment you would come from, right? But you can't garnish her SSI until potentially, at least, there's an argument that it would be transformed into something else. If that's indeed all her income, go ahead.
Well, I know Nancy Rose is a psychic, and she does a lot of readings in the past.
I'm sorry. What? She's a what? Wait a minute, she's a what? Nancy Rose is a psychic.
Well, I know Nancy Rose is a psychic, and she does a lot of readings in the past. And it's not always.
Man, somebody give Judge Simpson an award. Do you see how unfazed he looks? He's like, I've heard it all. This ain't nothing new. I would be dying. You do what? This is a court of law. We're not here to talk about unsupported science.
Always, above board. So she does have a past.
Let's drink,
and
Judge.
it's not always, above board. So she does have other income, which I
Okay.
to bring that up.
So
That's what you should start with. Not she's a psychic, and claim that she's good at it too, because you just confirmed she's a psychic and does readings. Versus, it is my understanding and belief that she has other income from her side deals that she does. She does readings, tarot cards, other services that yield her financial support.
okay,
So
what do you want me to do? Do you want me to give you a judgment for the full amount?
I don't ever expect, she gave me her word.
Okay,
that she would pay.
I asked a question.
I
How
don't
come
think
nobody
that's-
just answers my
No.
question? Do you want a judgment for the full amount?
I-
You want to say this through a trial?
Yes.
I mean, if that's what you want to do, let's do it. I mean, I'm trying to just give both of you the practical realities of it. That's all I'm trying to do. But if you want to sit here and we just go through the time of doing it, that's why I'm here. Let's do it. Mr. Allen, swear her in. I mean, it makes no sense to me. It's a waste. It becomes a waste of time that you two can't resolve this.
May I speak to my husband for 1 second?
You want to speak to
My husband?
your husband? Go for it.
All
Go
right.
ahead. Talk to him. Go ahead. I'm going to stand in brief recess. I'm going to step out for a moment. All right. Ms. Gerler will be right back. Okay.
Thank you very much, Your Honor.
Thank you. Court's in recess. We call the case of
My husband talks.
Pio versus Gessler. We call the case of, thank you. Court's in recess.
Uh-oh.
We call the case of,
Okay, so these comments are done by Old Squishy Garden. Thank you. Sometimes we agree, sometimes we don't necessarily agree, but I appreciate the perspective, and I always appreciate having the video made available to us. And something else is popping up on my screen. Okay, so let me put this where this goes. Oh, here. I don't know what the difference is. Okay, so yeah, we don't need that right now. Thank you. Okay, so it says, okay, we are back, and it was not just a few minutes, but stuck around to get closure for you. Thank you. We love closure. Appreciate you, Old Squishy Garden.
My husband talks.
Pio versus Gessler.
Well, my husband.
Hold on a
talks in
second.
sense-
Miss Gerler? I'm not Mr. Gessler. Miss Gerler, are you there?
Yes, sir, I'm here. You just
Okay,
had
there
to
you are.
technically
All right.
handle it. Thank you.
All right.
I will accept the $3,000 that you're proposing.
The 3,000 deduction.
Yes.
Okay.
Judge Simpson's so nice. Is the deduction, or you just want $3,000?
Ms. Gerler, did you understand what plaintiff was indicating?
Yes, Your Honor, and that is a satisfactory conclusion. Thank you.
All right. So I'm going to enter a judgment total amount. So here's what I'm going to do.
Your Honor?
No, that's not right. Hang on one moment.
Okay.
I have
I was
read.
gonna say he cut something. Okay, so he cut out the tedious part. Okay.
Let me just go through the figures so that we're all clear on everything.
Yeah, you know.
So I'm going to have a total rental amount of $12,950. But
Your Honor,
where
that's
I'm
not
gonna- but hold on a second. Hold on a second. Where I'm going to take the rental amount off, the 3,000 off, is I'm going to take it off of that figure.
Your Honor, the rent figure given is not accurate.
Which
should
part
be-
is not accurate?
The rent itself did not come to 12,900. Should be 11,900 and the change, not 12,000. That's adding another month's rent that was not applicable because she received the security deposit.
Well, no, I haven't gotten to that deduction yet.
Okay, so once again, security deposit is after everything is understood. Rent is, this is how much you owe, period, point blank. And then you start deducting or adding into the columns that are necessary. So this is how much you owe in rent. Are there damages? These are the damages. Okay, this is the financial commitment for those damages to be repaired. Did you pay anything over? Did you pay rent before you left? Oh, but we have a security deposit we held. So now you start deducting from there. Yeah, he ain't got that far yet.
Oh, I'm sorry, sir.
Yes.
Okay, so just let me get through the
And
figures,
don't-
and then
and
if
don't-
anybody has a
Don't interrupt a judge or an attorney doing math. Okay? We're not mathematicians. Let us work it out, and then you start getting into your question.
Oh, I'm sorry, sir.
Okay, so just let me get through the figures, and then if anybody has a dispute, given what you've said, then
Yeah, let us get through these numbers.
we'll do it that way.
I thought it was $10,301.
Hold on.
That-
No. Everybody just stay with me in my math, okay? I took the
Do not disturb the judge in math. Let them finish.
Everybody just stay with me in my math, okay? I took the 12,950, took off the 3,000 we talked about. That brings me to $9,950.
Mhm.
You're also claiming $68 of rent.
Okay.
That brings the figure back up to $10,018.
Then the court fees?
Ma'am, please. Without talking, just let me get through it and then we can back it off. Then I'm going to subtract out the security deposit, which was how much?
$995.
That's right, Miss Skirler. It was $995, correct?
That is correct, sir.
All right. So then, Emily, help me. I come to 9023.
Sounds good.
Okay. That then is the total judgment amount, and now I'm going to add the cost in. And the cost of
So that's the difference. So the judgment is this is what you owe based upon your agreements, your contracts, your civil liabilities. The cost of getting what you owe, the cost of court, the cost that was over to the plaintiff is something that's added on to you because truthfully, you should have been able to come to resolution without the court intervention. But since you were not able to come to resolution without the court intervention, then fine, we are here in court to settle the matter. So you are now responsible for court intervention costs. This is why her interjection was improper. One, because don't interrupt somebody doing numbers. Okay, let them get the math together. Then two, she was in the wrong column. So he is probably looking at his judgment sheet, and you get the judgment, and then you get the costs relative to the judgment.
that are added in that the court has is $215 plus $70.55 service fee for $285.55. Add those costs in, I come up with $9,308.55. That is the judgment amount and how I figured it. To the plaintiff, that figure is acceptable to you?
Yes, it is.
Ms. Gerler, is that acceptable to you?
Yes, it is, Your Honor.
Wonderful. All right. So what I'm going to need, yes, ma'am.
May I ask Nancy how she intends to pay that? Or if she, and what time frame?
This is court. It's not mediation. The judge went to the beginning of this matter and said, hey, you want $12,000. How are you going to get $12,000 from a turnip? The turnip is not even a turnip truck. How are you going to get it? How are you going to get it? And she proclaimed, well, she has other income. So, ma'am.
Can I explain?
Well, let me do it this way. Ma'am, did you want to enter into a payment plan at this point? Or do you want the judgment to enter and then you can file for, she could try to collect and then you file for, come back, and then I have to decide what the payment is? How do you want to do that?
Your Honor, there is no commitment that I can make at this time. I am not working. I have lost all the phone numbers affiliated with my business. I have had chronic problems with chronic illness, and even finding a permanent place to live. I
Got it.
certainly hope
Okay.
this changes in the future, and I will make every effort to pay towards, but at this point I can make no commitments because I literally do not have it, nor secure or stable additions to the Social Security income that I get.
Got it. So what that means is that you're left to the
Okay,
collection procedures that
all
you
right,
can.
that's
The
fine.
court will enter a judgment. Judgment amount of $9,023. Cost of $285.55 for a total amount of $9,308.55. All right.
Thank you.
You'll need to fill out a money judgment form out at the counter, and then once I get it, I'll sign off.
Okay, so we appreciate Old Squishy Garden. We did thumbs up, right? Yeah. Okay, so we have appreciated you. We have liked, and I'm already subscribed. That is part 2. Oh, okay. Hold on. We have. I don't know why that's making all that noise. Okay, so that was the second part of Madam Tenant Karen. That's her money judgment. And so the question of, okay, so how's she gonna pay? Like, yeah, how's she gonna pay? How's she gonna pay? She couldn't pay when she was in the enjoyment of the property every month, $800 something. Sounds like that was the rent. So she couldn't pay that on a monthly basis. Now she's in a new property with new financial commitments, and you have a judgment against her. Okay. She has to go through the collection process. And hopefully it will work out for the landlord, because it sounds like she's on a fixed income too, and she's entitled to her funds and she needs them, don't we all? I appreciate this. This was a great experience to get the wrap up of, and wanted to make sure you also saw the ending. This is to help you to learn about, my hair is doing crazy things. Okay, maybe this is better. This is a good piece of information to learn about the different process. So like I said, this is the court representation which is done normally very easily, not necessarily this deficient in cost, but even when you've paid each month, at the end of your lease, at the end of your possession of the property, you do a walkthrough, just like you do in the beginning. And the walkthrough has an actual paperwork that's assisted with it. So make sure that it's not just you actually walked through, have it written down, signed by both sides. Anyway, you do the walkthrough beforehand, you do the walkthrough at the end to ensure that the property is given back in possession of its rightful owner with no damage. And if there is a damage, then they calculate those damages, and there's reasonable damages that you can ask for. And cleaning fees still is not acceptable. I thought the way she said it, I was like, oh my God, you can do cleaning fees? Nope, still not acceptable. So you're supposed to clean it anyway. Now, if there's something crazy, like what would be some, say they painted a room all red, and that was never approved for them to do, so you have to clean that by getting it repainted, that would be a reasonable cleaning that you would charge the tenant. If they wanted the bedroom bigger and just opened the wall into the next room, and now 2 bedrooms are combined, that's a major construction that you have to fix. So obviously you would put that against the tenant's charges. But as far as like sweeping and wiping down and using Clorox bleach and stuff like that, no, that's not typical for cleaning. And then even when you have carpet, which you shouldn't have carpet at this point in life, but some people still have carpet in their house. So if you have carpet and you say, oh, I had to get the carpet cleaned, well, you should have been doing that anyway. But if you say, oh, they had a big burn spot in the carpet and I needed to, change out this section and get, new carpet laid down, you would charge against that. So certain things at the base level is not the responsibility of the tenant, whereas when it's heightened and it's unreasonable is usually the the line of measurement if it's reasonable or not. When it's unreasonable, that's when you can charge against the tenant. Okay, so we learned, we're doing things. We know things now. Make sure you like and share this information with someone else. Maybe they don't know. Maybe you say, "Oh, of course I knew that. I've been on this earth for 50 years and I've known this all my life. And of course this is the case." Great. For everything that you think is common knowledge, there is at least 100 people who don't have an idea. They're like, "No, we don't know. No, we never heard of this. We didn't know that was true." So share. It's okay. Like, share, subscribe. But at the very least, if you can't do anything else, get that thumbs up, subscribe. I don't do a million videos, so I'm not spamming you, right? Right? So subscribing is not going to hurt you. You're not going to, go, "Oh my God, the real estate advocate again. Oh my God, they keep doing another video. Oh my God." No, we have days that we do no videos. Some days we do 2 videos. Who knows? All right. So Lyric Armstrong here, your real estate agent and advocate. See you at the next video.